And while you all settle down, ladies and gentlemen, we will now begin by introducing our chair for the session as well as our speakers. And as I introduce them, I'd like to invite them to come and take their seats right here on stage. So, session 3, ladies and gentlemen, is titled Law Reforms and Enhancing Regulatory Frameworks. The chairman for this session is Mr. Kuvera de Zoysa, President's Counsel. He was admitted as Attorney at Law of the Supreme Court of Sri Lanka in 1993 and as a President's Counsel in 2012. He holds an LLM in International Trade Law from the University of Wales. He has extensive experience in the areas of civil law, corporate and commercial law, banking law, international trade law, investment law, insurance law, maritime security law, corporate commercial-based litigation and arbitration, and sports law. Notably, he has also been appointed as a member of the International Court of Arbitration. Mr. de Zoysa has been appointed by the Ministry of Justice, Prison Affairs and Constitutional Reforms as a member of multiple committees to propose, draft and review necessary amendments and new legislation, notably for the Committee to develop a new Anti-Corruption Act, the Committee to develop the law on proceeds of crime, the Task Force on Prevention of Financial Frauds, among many others. So with this introduction, ladies and gentlemen, let's now welcome our session chair to join us up on stage. This is Mr. Kuvera de Zoysa, President's Counsel. Let's put our hands together as we welcome him. And joining our session chair on stage are our speakers. Allow me to introduce the first speaker for this session. We have Ms. Lihini de Silva, who currently serves as the head of the Department of Public Law at the Faculty of Law, General Sir John Kotalavala Defence University. She's also coordinator of LLM in Public Law program. She holds the degree of Master of Philosophy in the area of Intellectual Property Law from the University of Colombo. Let's welcome our first speaker, Lihini de Silva. Our next speaker is Mr. Harsha Fernando, President's Counsel. Leading his own law chambers, he offers services in various legal domains, spanning civil, commercial, and appellate court litigation. He consults for the Asian Development Bank, European Union Delegation, Japan International Cooperation Agency, and the World Bank. He was recently appointed a Commissioner of the Securities Exchange Commission of Sri Lanka. He holds an MBA from NTU Singapore and MIT USA and an LLM in Economic Regulation from King's College London. Ladies and gentlemen, let's now welcome on stage Mr. Harsha Fernando, President's Counsel. And our final speaker to join us up is Dr. Arittha Wickramanayake. He is the Precedent Partner of Heritage Partners, Attorneys at Law. He commenced his career at the Attorney General's Department as a State Counsel. He has postgraduate degrees in law from Europe and the United States, as well as a master's degree in law and diplomacy from the Fletcher School of Tufts University in Boston, Massachusetts. He received his doctorate in law from the University of Colombo. Let's welcome our speaker, Dr. Arittha Wickramanayake. And with that, we are ready to get started with session 3, ladies and gentlemen. This is Law Reforms and Enhancing Regulatory Frameworks. I now hand over control to our session chairman, Mr. Kuvera de Zoysa, President's Counsel.
Good afternoon to all of you all. And let me take this opportunity to first thank the OPA for having this session on a very timely topic that is towards Sri Lanka's sustained economic growth. Now, the 3 subtopics that have been selected for the current session, I say is important because in the backdrop of Sri Lanka being ranked 99th out of 190 in the ease of doing business index and also 164th position out of 190 in enforcement of contracts. So that speaks volumes. So in that context, we have 3 eminent speakers who are all sector specialists in their respective fields. And let me invite Ms. Lihini de Silva to make the presentation on the topic of strengthening intellectual property rights protection. Thank you.
Good afternoon, and thank you very much for the invitation. The topic I have been invited to speak about is strengthening intellectual property rights protection. So when you say intellectual property rights, I think patents, copyrights, trademarks. So these are the first that come to our mind. But I thought of talking about a different topic, that is geographical indications. So some of you may have heard of that, but some of you may have not. Of course, the legal professionals, they are well aware of geographical indications because we have this recent Intellectual Property Act amendment which came in 2022 that was totally for regarding the protection of geographical indications. So what are these geographical indications? So you may have heard of Ceylon tea, Ceylon cinnamon, yes, and French champagne, right. So these are the geographical indications. So these geographical indications, they are associated with a particular product which originate from a particular geographical area, and they possess certain qualities, reputation and characteristics which are essentially attributable to a particular geographical origin. So that is the uniqueness of these geographical indications. So why I am talking about geographical indications? Are they that much important? Yes. So I would say that geographical indications are the forgotten stepdaughter in the field of intellectual property arena. They can bring a lot of socio-economic benefits to a country. Especially now if you take European Union, India, they are very concerned about the rural development. And also geographical indications, they are considered as a symbol of cultural heritage. So in terms of these aspects, so there's a lot that we can receive if we have a very strong legal framework relating to geographical indications. So if I may now turn to the recent amendment, 2022 amendment. So this has introduced a registration system for geographical indications. Now before this 2022 amendment, what we had was the 2018 amendment, which entailed just one provision, and this provision empowered the minister to prescribe geographical indications. My opinion is actually this 2018 amendment reflects a very outdated law, because in France, of course in 1905, because France is where these geographical indications originated. So in France, they at that time in 1905, they empowered the administrative authorities to prescribe geographical indications. But then they understood that there are many lacunas in these laws, and now more than a century has gone since they abolished this law. So, and they have now a very comprehensive legal framework. But after even after a century, now Sri Lanka introduced this 2018 amendment which empowered the minister to prescribe geographical indications. So now the European Union, that regional law, and France, so these European countries, what they are mostly focused on is a producer-based system. But in 2018, with this amendment, Sri Lanka introduced a top-down approach where the state intervention exists to a larger extent. That is, of course, considered as a very outdated law in the international context. So then, now that was the time even I was engaged in so much of field research in this area. So that was the time where Sri Lanka was trying to register Ceylon tea and Ceylon cinnamon in European Union. So that's why this amendment was, of course, came in 2018. But unfortunately, due to these shortcomings existed in this amendment, then we had to introduce this 2022 amendment to address these shortcomings of this 2018 amendment. Now, in the 2022 amendment also, now my understanding is actually now Sri Lanka is following the Indian approach rather than the European Union approach. So now who can apply for a geographical indication? So now, as I said, few examples, Ceylon tea, Ceylon cinnamon, even now they are, I mean, many people are aware of these geographical indications, so, but not limited to. So there are many other potential geographical indications, like you may know, Ambalangoda masks, Dumbara mats. Of course, in Sri Lanka, we have not registered these geographical indications because the regulations are still pending. But in India, there are many handicrafts which are registered because they are very focused on the benefits that they can get from registering these geographical indications. And in European Union also, now since 1992, they have regional laws with regard to geographical indications, and after this 1992 regulation in European Union, then they introduced a regulation into 2006, and then again they developed their law, and then they brought in a law in 2012, and again in very recently in 2022 April, they introduced they are updating their law, a very comprehensive legal framework pertaining to geographical indications, and that was regarding agricultural products. So in Sri Lanka, as I said, Ceylon tea, Ceylon cinnamon, and of course Ceylon coconut. So these are potential geographical indications. So not limited to, but these geographical indications are not limited to agricultural products. Of course, we can extend them to non-agricultural products as well. So there was so much of debate in the international context whether we are extending this protection to non-agricultural products. In European Union, so in 2023, after long-standing debates, they introduced a regulation to protect non-agricultural geographical indications as well. So those are crafts and handicrafts. So in India, of course, they have recognized non-agricultural geographical indications. So in Sri Lanka, the main international convention we have with regard to geographical indications is the TRIPS agreement, Agreement on Trade-Related Aspects of Intellectual Property Rights. So there's no barrier according to the TRIPS agreement. And so Sri Lanka, so this according to this 2022 amendment also, which came to the Intellectual Property Act, there's no barrier to register non-agricultural geographical indications. So we have Sri Lanka if we are to register geographical indications, we can register Ceylon tea, Ceylon cinnamon. At the same time, we can focus on other non-agricultural geographical indications like Ambalangu damasks, Dumbara mats, those products as well. So if I may now look at who can apply for geographical indications. Of course, according to the Amendment Act 2022, it says producer associations can apply for registration. At the same time, governmental authorities can apply for geographical indications. So that's why, so this situation is similar to the Indian situation. So that's because in India, not only the central government, but also the state governments. In addition, certain governmental departments, not limited to that even, governmental universities, they are engaged in researching on the geographical indications and also registering, they are initiating the registration process. So in Sri Lanka, so now we have, I would say that this definition of the applicant is a carbon copy of the Indian definition. So we are more towards this Indian approach. So like India, in Sri Lanka also, the state institutions can register geographical indications, and we have also seen now, even though we have not registered geographical indications, we have seen, so still the mechanism that we utilize in the protection of geographical indications is the certification mark system. So we have seen Export Development Board initiating the Ceylon cinnamon registration as a certification mark, and Sri Lanka Tea Board initiating the registration of Ceylon tea as a certification mark. So that is the approach we see in Sri Lanka as well, something similar to the Indian approach. But if you look at the European experience of France, this situation is completely different. They don't follow this top-down approach. It's a producer-based mechanism that they follow. So the registration mechanism starts from the producer level. But in Sri Lanka, of course, most of these geographical indications are linked with rural areas. So of course, we understand that these people or the producers who are engaged in producing these goods, they are unable to come and register geographical indications. So there must be some support from the state. But at the same time, we should also not forget that there can be some biasness which may occur as a result of the state intervention as well. Because India has experienced such situations. When they went to register Mysore silk, where the application came from Karnataka Silk Industries Corporation Limited. So they indicated that they are the only producer, but it was challenged by several other entities, but it was defended because the application came from a state-owned company. So such situations may arise if we are to rely on a strict top-down approach. And in this 2022 amendment, has defined about authorized users who can use the name of a geographical indication. So, although it has defined authorized users, the Act doesn't mention anything regarding authorized users in the subsequent provisions. Only the definition it contains, nothing else. Whether the authorized users have to be registered or what rights they have, nothing in the 2022 Act. So such lacunas are there in the 2022 amendment. And apart from that, so what about now geographical indications? So they indicate a particular origin. What is the link between geographical indications and trademarks? So they also indicate the origin, trademarks. Does this 2022 Amendment Act talk about, or does it entail any provision regarding this connection between geographical indications and trademarks? No, it doesn't entail any provision which discusses about geographical indications and trademarks. 5 minutes, okay, thank you. So it doesn't entail any such provisions which discusses about the connection between geographical indications and trademarks. The issue that arises here is now Dumbara mats or Ruhunu occurred. So if a trademark is registered under such name, and later once we establish this registration system for geographical indications, which name will prevail? So we should have answers for these questions. And if a geographical indication comes first and then comes a similar trademark, then which name to be prioritized? So no answer has been provided in the 2022 Amendment Act. So of course the TRIPS agreement, as I mentioned, the agreement on trade-related aspects of intellectual property rights. So this provides clear provisions regarding the connection between geographical indications and trademarks. Apart from that, I was referring to the European Union regulation. So European Union regulation also entails very clear provisions. So at the same time, I was referring to the Indian Act because we are following the Indian approach mostly. Even the Indian Act entails provisions with regard to the connection between geographical indications and trademarks. But unfortunately, in Sri Lanka, even the 2022 Amendment Act does not entail any provisions which talk about the connection between geographical indications and trademarks. So I believe that these shortcomings need to be addressed if we are to maneuver towards registering geographical indications in the future. So otherwise, we will have to face insurmountable issues once we establish the registration system. Thank you so much.
Thank you, Lihini. I think you have finished on time. Thank you for that. Now let me call upon my good friend, Mr. Harsha Fernando, to deliver his presentation on reforming commercial laws to promote business growth, which is also a very important topic in today's context.
Thank you, Kuvera, and thank you, OPA, for inviting me. I don't know why you decided to put this session immediately after lunch. I sometimes feel that the legal profession might be a little discriminated within the OPA. I have got a presentation ready which I made available to the organizers. Okay, so you're going to click when I talk, yeah? Super, thank you. So the topic I've been given is reforming commercial laws to promote business growth. And I've been given 20 minutes, of which I've already finished about 20 seconds. Now, whether I can handle this topic in 20 minutes is, I can't, don't have any expectations, I can't. So therefore, what I have tried to do is I have tried to perhaps leave with you a framework to approach this topic and as professionals to make sense out of it. Next slide, please. I will start by, as most lawyers do, we start by giving a simple definition. I believe in keeping it simple and stupid. That's easy. So I would invite you to consider commercial law as a body of legal rules and regulations that govern the conduct of business activities and commercial transactions and their enforcement. So basically, the law provides the enabling environment for everyone else to do what they're doing, make their money, whether it's entrepreneurs, professionals, whoever who is engaging in any activity that will create value and ultimately contribute to the economy and the GDP. Now, one of the points that I would like to make, and it's very important from a context of Sri Lanka, is that we tend to, and lawyers are very guilty of this, to look at commercial law in sort of pure law principles. It can't. It's a very social phenomenon. It is based on history, our social interactions, the way we have been doing things, the way we have been doing business. So therefore, getting a contextual understanding and a perspective of commercial law is absolutely critical even before you even start talking about reforms. So I'm going to share with you maybe 6 points that I use to understand any law, commercial law included. So I'll just go through it very quickly, and I have given my own assessment of these 6 indicators for Sri Lanka. So the first is the ideological foundation. I mean, we have been playing ping pong with our ideologies, economic ideologies and economic policy, and we're going for another round on the 21st of September. So the underlying political ideology and the government takes shapes business law. How we deal with business, how we deal with property rights, the questions about ownership, this whole debate about private ownership and state ownership, all that is linked to the government ideology. So it's critical. Second one is our legislative and regulatory powers. That is where how our political system is organized. Now, if you're wondering the way Sri Lanka operates, if you analyze all the commercial laws, except for things that are pure, like dealing with non-governmental entities, very few, everything else has discretionary authority vested in a public official or an elected official. If you start looking at those, I mean, you can't do anything without the minister giving you a permit or some public official sitting somewhere giving you a permit. If you begin to see law that way, you will also understand why some of us are very keen to serve the public and get into public office, elected or otherwise, because you have an enormous ability to exercise discretion on things that make money for your, not for you, but for the country, right? So I think in the interest of time, I'll give you my assessment of this also and then explain, because then you will know where I'm coming from. So for the ideological foundation, I put these smiley faces because I knew this was going to be after lunch. So if you look at the smiley faces, it's been up and down. Reversal of policy within a space of 10 years is not new to Sri Lanka. Complete reversal of policy. Midnight gazettes is the run of the mill, but complete reversal of policy. In our lifetime, how many times have we seen reversal of policy? And we might see another one in September, depending on how the election goes. So as a result, people are smiling, but they're going up and down. And now we come to a point of anger, very angry, and now everybody is confused. If you look at legislative and regulatory powers, it's organized in such a way, public is confused, but you have liars, ghosts, and clowns. It has given enough space for these personality types to emerge that is impacting business. So there is little that the commercial law, you can pass the best law in the world, but if the contextual application of that law is not understood, if those nuances are not understood, you will not even get half the impact that it is supposed to get. And this is where we miss, because there is a complete disconnect between those who draft the laws, those who pass the laws, those who apply the laws, and those whose lives are governed by the laws. Absolute disconnect. The next is the country's judiciary. Since I'm a lawyer, I'm not going to talk about it, practicing lawyer. But certainly I have put the skull as to show that some litigants are dead by the time the result comes out. I've recently did an assessment for over about 3 to 4, 5 years about the Sri Lanka justice sector, and we proposed a huge number of strategies on behalf of the Asian Development Bank. Analyzing just 2 years, the actual dates on which the case was filed and the judgment was out, we found that, for example, in the district court, where your property rights enforcement happens, land, average, you take about 24 years to complete in appeal, and that's an average. There are cases that go more time than that also. A commercial law matter to go to the Supreme Court and finish the matter, it took about 18 years. So if you take 24 years to get a property right enforced, forget business. Nobody wants to do business unless you are going to refer to extrajudicial methods to resolve your disputes. Corruption and integrity, it's like a danger sign on radioactive material for the investor, right? Any investor that you speak to, and in our professional work we meet investors, they come with a mindset of how do we deal with the corruption and the thing that we're going to be confronted with. It's no longer the exception to the rule, it is the rule. International relations and trade agreements. Only now, we have signed 7 trade agreements, regional, including, I think we have signed the RCEP now, which brings us into Australia. Not yet, or it's getting there. Now there you have certain very powerful commitments we have made. One example, classic example is competition law. I can speak about it because I recently finished an assessment and made a recommendation as to how to move forward in competition law in terms of bringing it to Sri Lanka, because I think that's a very powerful policy tool. We don't have to keep changing policies between certain isms, but through competition frameworks, you can actually bring in certain social safeguards that we need to have in our markets. Now those things are there, but those are not getting translated, and those who are committing to those agreements, I don't know how much they appreciate as to how much of it those can be actually implemented through a framework here. And I put that little other sign is, that is for the professions. We are dead against integration. We are very protective of our own professions. We don't want competition. I don't know whether it's out of ideology or whether out of fear of competition. We don't want competition, so we create Halloween type fear amongst the public, saying don't allow professions to be open, legal profession included. No investor is going to depend on me to bring in $1 million into Sri Lanka and not allow his own lawyer to come and tell him whether he's safe with his money. That's the reality. It applies for doctors, it applies for accountants. Political stability and policy continuity, having a predictable and consistent commercial law for long-term investment and strategic decisions is critical, so you know where we stand with that. I mean, this is not all negative, but I think it's important that we start talking about the things that we need to change. Having said that, why should we reform commercial law? So commercial law framework is a foundational infrastructure. It's like the foundation upon which business can thrive and contribute to the overall economic development of the country. So we need to see that as an enabling environment. It's not the be-all and the end-all. You lay the foundation right, business will find a way, the entrepreneurs will find a way, and the value addition will come in. So how do you approach this? So to do that, when you say commercial law and business law, you put it together, you are looking at large number of laws. It's very difficult to do justice to a title of this nature within a very short period of 20 minutes. So I brought in this framework. I try to, it's a very ad hoc categorization, as I said again, to try to make sense of this topic. I am categorizing them into 5 categories: enablers, regulators, facilitators, enforcers, and developers. Enablers are those foundational laws that we need for commerce to happen. Without those, don't even think about it. Then, of course, the regulators are the guys who make sure that the market operates according to certain principles, which, if properly applied, will bring in the kind of outcomes you are looking for, including social protection. So, the competition regulator is a classic example. Facilitators are those who support and smooth functioning of commercial transactions. Enforcers are the guys who make sure that everybody plays by the rules. And the developers are that category that, depending on our specific economic needs, will bring in certain types of laws to encourage development of certain sectors in the economy. For example, laws to encourage foreign investment. More FDIs is an example of a developer. So here I give you some examples to further illustrate the classification. If you look at the enablers, we are looking at contract and property laws, land, shares, leasing, etc., business ownership structures, and finance laws. So what's the status in Sri Lanka? I think my previous speaker went deep into the intellectual property part of it and made her observations even on the latest amendment. So I think they're slagging, they're constraining, and in the enforcement, there's a lot of corruption. And our legislative policy is such that we can't get out, shake off that colonial whatever that we have inherited, where a minister has to take every policy decision. Every law, it's the minister that decides. And our whole legal system is premised on this discretion being given to an elected official. I'm not saying it's bad, it's good for democracy, but it's operating in a country like Sri Lanka, that's anybody, I mean, you know the answer to that. If you look at the regulators, our competition laws are extremely weak. 78, we opened the economy. That was one angle that was completely forgotten, and as a result, as a national psyche, we are dead against free markets. The whole reason is we had the worst examples of free markets because we did not see those market harnessing techniques or laws parallelly developing when we were forced to open the economy in 78 to deal with the economic crisis we were facing at that time. And now everybody is blaming the policy without realizing that our competition laws actually could have got some of these social outcomes that we are looking for in terms of low price and in terms of good quality and universal service obligations if we had only been a little more sophisticated in doing that. Enforcers. Facilitators, again, intellectual property, electronic transaction, secured transaction. If you look at the years, you know what I'm talking about, 2006, 2009, we are in 2024. Amendments have been brought, but as a practicing lawyer, I can tell you, every time I have an electronic document in my hand, every time I have a SMS in my hand which I want to produce as evidence, I always have that little doubt, will I run into some problem with the other side taking an objection? Because the evidence is not so clear. And even if I get it cleared in one court, I do try to do that in another court, I have to face the same set of challenges again. So this all adds to the way we do business and the environment to do business. And then, of course, enforcers, the Insolvency Laws, the Judicage Act, World Bank, the last time they did the assessment, we take 1,300 days for contract enforcement. I think it's a little bit, maybe a little bit plus or minus. So if you take 1,300 days, that's basically about 4 years to get a contract enforced. I'm surprised that we want to do business in this country, right? And the answers are there. And then, of course, the developers, you have the investment laws, and now I think Mr. Wickramanayake will talk about the next act, hopefully the next thing after we done with this set of laws. I mean, in 78, we brought in a new set of institution, new set of laws because we needed new ways to deal with the challenges. But most of it is outdated. BOI is struggling to be that one-stop shop that it is supposed to be, struggling, experimenting with all kinds of methods. And our legal system has got so, confused that we are feeling it. So, what do we do about it? Again, keeping it very simple, and these are very generic, and I apologize to you for doing that. It will apply for any country, not only for Sri Lanka. 7 little things: simplify and streamline
Harsha,
laws and regulations. I'm keeping a tab on it. Thank you. Simplify and streamline laws and regulations. Enhance contract enforcement and speedy dispute resolution. When you say enhance, how confident are you that if you give a loan that you can recover it? That's what I mean, the quality of that enforcement. Modernize commercial transaction and digital commerce. I recently returned from a country in Southeast Asia. In the tuk-tuk, I pay with a QR code and my phone. I don't carry cash. I can do that in one of the top companies in Sri Lanka, and I'm wondering who is holding them back. And sometimes it's a fear that the regulator is scared to open it up. A simple QR code. Foster access to finance and investment, encourage innovation and IP protection. Encourage, it's not about protecting. We have this whole protection mentality. What about encouraging through protection? That encouragement part is that's what's missing. How do you make a law bankable? How do you attract investment based on the law? Introduce and improve fair competition and market efficiency and enhance transparency and good governance. I know it sounds like a big list, a laundry list, so I'll finish with three priority areas. What are some other two key things that are facing us now? All the political slogans that are floating around, forget about it. We need two things. We need to earn forex and then allow people to earn more money so that we can tax them to pay our debts. Very simple. Now to do that, again at a macro level, three things I'm proposing is just take a simple process. If you want to import something, what's the process we follow? Find the blocks, change it, and do that process re-engineering and change the laws where it's necessary. It has to be a combination of IT, law, policy, all combined together. Second type of recommending is what I call review and reverse the ratchet. We are in a regulatory ratchet. We pass a law, it never gets out of the statute books. We pass another law on top of that, another law on top of that, another law on top of that. So when somebody comes and asks a lawyer, can you do a due diligence and give me a risk-free certification, it's a nightmare. If you analyze the number of laws passed by the legal draftsman in 1 year, you will find at least in 4 or 5 laws, notwithstanding any other provision in any other law, this law will prevail. Right? So that takes away the certainty in the market. And the last one is we need to convert discretion into ex-ante standards. Right now, you do everything. I mean, right now I have a client who is asking me to do a due diligence and tell me if I invest in this particular venture, is there a risk that the government might overturn it? And I can't give him an answer, either yes or no. So,
Harsha, you have 2 minutes.
So we have to get out of this situation where we are depending on the discretion of somebody. So what we are recommending is take the discretion out, put the laws and say if anybody is compliant with this guidance, by right, you have the right to do whatever the business activity we are doing it. I was involved in the recent amendments to the Telecommunication Act through the World Bank. And to some extent, we brought this principle in, I like to say for the first time, but not necessarily, but in a very emphatic manner, we brought that principle into the Telecommunication Act to take away discretion, but basically saying, if any business person satisfies these criteria, you have the right to practice until somebody says no. So we reverse the whole approval mentality. So these are just simple 3 things. Whether anything will come out of this conference, I don't know. But I feel complete that I have sort of shared this with you. So here are some of the success stories, 1 minute. I'll just take India. India just took that ease of doing business as a project in one of the states and changed everything. So they took it as the outcome and worked backwards. And what happened? Within 6 years, they improved their rankings from 142 to 63. Right? You take another one, Colombia. Now, Colombia, they brought in a centralized collateral registry, which classified this ownership. And then what happened? Within 3 years, there was a loan disbursement increase in 60% of the loans, because the people now had a collateral and they had access to finance. Simple things. Law is a very, very powerful tool. And if you strategically use it in combination with the economic and business experts, you can get marvelous results. And I think Sri Lanka is at that particular point to do that. I have made this point an existential question. I think I should put the date 21st September next to that. I think we are going to answer that question on the 21st, because one good thing that came out of the economic crisis is we have been forced to take a stand on some of the major policy debates which the rest of the world settled 50 years ago, which we are struggling. Right now, at least, we have been forced to take a stance, and I can see the usual suspects keeping their mouth shut, but now they're all coming out of the woodwork again. So, organizers, thank you very much for inviting me. My final point is, we see law as an enabler. as a foundation. And as long as you appreciate it in the utility value of the law in that way, then this topic will become relevant in moving forward. Thank you very much.
Thank you, Harsha, for that very thought-provoking your presentation. I'm sure there'll be many questions on that. Now, we are now approaching another very interesting topic. I invite Dr. Wickramanayake to make his presentation on improving regulatory framework to attract FDIs. I think that is something much spoken of in today's context, and which is a very, very important topic for Sri Lanka.
Thank you, Mr. Chairman. Yeah, I've been asked to share my thoughts on improving the regulatory framework to attract foreign direct investments. Now, I know that many of you are expecting me to focus on the Economic Transformation Act. So though I believe that a single law can't really transform a broken system, and the subject needs wider discussion, I will restrain myself this afternoon and focus on that law, especially because there are a lot of misconceptions about that need to be clarified. However, let me begin with a brief thought on the overall challenges in attracting foreign direct investments in this day and age. The challenge in attracting foreign direct investments has fundamentally changed over the years. What Singapore did to attract FDIs in the 1970s, or the GCEC did in the 80s, or even Vietnam or Bangladesh did in the more recent past, are no longer relevant to us. Remember, Singapore was the only investment destination in the region at the time. The GCEC, Mr. Vatavelu will confirm that, operated at a time when the president who backed the institution was all powerful, and there was very little decentralization at that time. Vietnam and Bangladesh offer large internal markets and low-cost labor. We no longer have any of these advantages, and in fact, we have been further burdened with a load of baggage that include expropriations, inconsistent fiscal policies, labor shortages, high costs of power, political and economic instability, and weak and administrative legal infrastructures. So as Harsha says, I'd be surprised if anybody invests in this country. So gone are the days when you could expect to attract FDI by touting our friendly smiles, our beautiful beaches, or even the generous incentives we tried to give once upon a time, which we in any event can no longer afford. Now, in this background, we need to recognize that strengthening the regulatory infrastructure is just one aspect of building a satisfactory climate for foreign direct investments. Foreign investors don't merely look at the investment law. They also look, among other factors, the broader regulatory framework that affect, again, amongst other things, the sanctity of contracts, dispute resolution mechanisms, and the ability to enforce judgments. Our corporate laws, foreign exchange laws, tax laws, data protection laws, IP laws, and a whole host of other laws that affect the operation of a business. So clearly, we can't examine the whole gamut of these problems within the limited time we have. I will therefore now turn my attention to the Economic Transformation Act, number 45 or 2024, called the ETA, and examine what I believe this law sought to accomplish from the perspective of strengthening the FDI framework. Let's start with a question that many are asking. What are the reasons for bringing in a new law? Why could it not have been done by amending the then existing BOI law? In my opinion, the answer is quite simple. The BOI was broken and moribund. Its performance was disheartening. It was overstaffed, unfocused, and rudderless. The official figures published by the central bank will testify to that. I'm not making it up. The original powers of the BOI had been gradually stripped away. Its policies were ignored, and more importantly, its stature had been eroded over time. It also had to compete on an unlevel playing field with the new darlings of politicians, such as the Strategic Development Act and the Port City. Overall, it was a demoralized entity. The new law and the creation of a new institutional framework will hopefully address this. The objectives of the Economic Commission have been clearly enunciated in the new law. A new mandate has been given. New powers have been vested. This redirection in purpose should hopefully result in a new beginning and a fresh burst of enthusiasm. Now, as I observed, a sustainable FDI structure cannot be achieved without a clear plan. Since we no longer have the competitive advantages in production costs, labor, political stability, or even the ability to provide incentives, we cannot expect investments to flow in because of our natural attractions. We need to set the ground for targeted investments by building the necessary physical and regulatory infrastructure. We therefore have to evaluate our advantages and interests. One of the few remaining advantages we have, in my opinion, is our strategic location as a gateway to South Asia and the potential as a center for exports. This also fits in with our requirement to improve our balance of trade to create employment opportunities. Now, this is explicitly recognized in the Economic Transformation Act. Moving on, merely identifying objectives is not sufficient. It needs to be translated into policy. The Economic Transformation Act addresses this by requiring the formulation of a national policy of economic transformation. The Economic Commission plays an important role in this process. It is required to formulate and recommend to Cabinet the national policies on investment, international trade, and investment zones to enable the realization of the national policy on economic transformation. This process is inclusive, requiring the Economic Commission to consult and coordinate with other agencies having responsibilities for substantive matters relating to investment and international trade and in formulating these national policies. Once this policy is approved by Parliament, it becomes a national vision rather than an internal document of the Economic Commission. It binds the Economic Commission and other related statutory bodies, provincial councils, provincial ministries, departments, and any other local authorities to comply with these national policies on investment, international trade, and investment zones. The Economic Commission has been set with some guiding priorities in formulating this policy. They include formulating schemes and measures to ensure that existing investors are encouraged to retain, reinvest, and expand investments in Sri Lanka. This is important because a lot of the existing investors are actually trying to go out rather than reinvest here. By digitizing and creating a transparent regulatory and operational environment, including the process of registration and the approval of investments in order to facilitate people coming in. And that addresses something that Harsha raised earlier. It also requires it to take measures to ensure that trade negotiations will be aligned with Sri Lanka's strategic export and investment objectives to reap the benefits of the trade investment nexus, and to propose strategic policy for actions and undertake periodic reforms of these policies. I want you to think about these very carefully because this is a well thought of plan, a structure, a mechanism by which you can make these policies work. It is not merely a statement of policy. Now, as I said earlier, we carry a heap of historical baggage arising from short-sighted actions of governments in the past. The expropriation of investments, the reversal of fiscal policies, and failures made to meet commitments to investors in the past have resulted in our stock being at an all-time low. This is painfully reflected by the total lack of interest which are shown toward the privatization program of the government. Unless investors can seek the protection of bilateral investment agreements, they are left to the mercy of the local legal system when their rights are violated. Harsha has explained what that can actually entail. Naturally, this deters investors from coming here. This act has interestingly sought to address this situation. Chapter 9 of the act, which I encourage all of you to read, seeks to entrench certain basic investment guarantees to investors who register their investments with the Economic Commission. They include fair and equitable treatment, national treatment and most favored nation treatment, free transferability of funds arising from investments, and guarantees against indiscriminate expropriation. Now, although this surprises some, I can assure you that these are standard principles which are contained in any investment agreement or the FTAs. Extending them to investors is therefore, or rather extending them to any investor is therefore not prejudicial to the country, and it in fact signals our commitment to treat investors fairly should they choose to locate in Sri Lanka. Another problem that existed with the earlier system was the unnecessary administrative procedures in obtaining approvals for investments. There were many instances where investors were frustrated with the hassle of this process. By the time approvals were granted, investors had chosen to locate elsewhere. The ETA radically simplifies this process. No tedious approvals are required any longer. All investors need to do is to register with the Economic Commission. That said, the minister can prescribe a negative list. He can also prescribe entry requirements with the approval of Cabinet for reasons of national security, public emergency, public safety, and environmental protection. If you ask the officials in the BOI why they were hampered in promoting large investments, they would almost universally tell you that it was because they were blocked from granting approvals by other government departments whose approvals were required. The problem was that since the time of the GCEC law, much has changed. As I said, there has been a decentralization of power and the erosion of the president's or the minister's powers to get things done. So the result was that when the BOI sought approval of line ministries and other government departments, the requests usually ended up in a dark hole. This silence usually meant that the investor was powerless. The ETA now provides that when an investor applies to the Economic Commission for approvals from specified government entities, it will be empowered to actively facilitate their procurement. The minister can, in collaboration with the specified institutions, work out standard operating procedures which will govern the vetting of such applications. These specified institutions are obliged to respond to such inquiries or requests, consenting to or objecting to them within 15 days. If the specified institution refuses to respond to such an inquiry or denies such a request, they must give reasons in writing within 21 days of the request. If the specified institution denies or fails to respond to a request, the Economic Commission can refer the matter to Cabinet for appropriate action. Remember that even if Cabinet fails to act, once reasons are given refusing or denying an application, or reasons are not given within the specified time frame, the applicant can use that to challenge it in a court of law. The ETA also seeks to address some other practical problems that were faced until now. One complaint about the present BOI was the perception that there were conflicts of interest within its membership. This has been specifically addressed in the law. If members of the EC board have a direct or indirect interest in any matter that involves the exercise of discretion of the Economic Commission, they must immediately disclose such interest and have it recorded. They also cannot participate at such meetings. If they fail to declare the conflict of interest, they will be disqualified from being on the Economic Commission board. Let me touch upon one other aspect.
Dr. Wickramanayake, you have
Yes.
5 more minutes.
Let me touch upon one other aspect regarding the EC, and that relates to investment promotion. Investment promotion has been one of the bigger weaknesses in our ability to attract investments. If one looks at countries that have succeeded in this game, their success has been to a large degree due to effective investment promotion. The BOI was hampered in doing this by the inability to recruit people with proper skills. When they tried, employee agitation put a stop to it. The Act now permits the Economic Commission to set up a company called Invest Sri Lanka, which will specifically identify investment opportunities and promote Sri Lanka as an investment destination. It will also assist and facilitate investors, connect local investors and foreign investors, and actively engage in such activities. There is one other crucial aspect of the law that I need to touch on. The general theme that I followed so far has been on the need for creating an infrastructure that will facilitate investments. A major problem that a lot of investors face here is a lack of physical infrastructure to start their businesses. The delays in obtaining approvals, ranging from environmental approvals to building approvals, has resulted in deterring investors. A strategic measure that is being taken the world over to meet this is the creation of economic zones for this purpose. Economic zones don't mean clearing a plot of land and demarcating it. Modern industries, especially those that are advanced, modern industries have very advanced and specific requirements. Creating this requires a huge investment and expertise, which is beyond the capacity of a state-run regulatory agency like the BOI or even the Economic Commission. The Act recognizes this and creates a special institution called Zone Sri Lanka, which will be responsible for promoting the creation and operation of zones. They can be operated by Zone Sri Lanka, as will be the case of those zones that are presently being operated by the, or over-operated by the BOI, or as joint ventures between the EC and private enterprises, or purely as private enterprises. The Act recognizes a variety of investments which Zone Sri Lanka will focus on. They include industries, IT, science and technology, high-tech agriculture, tourism and recreation, business activities, and even livestock. Based on specific requirements, they could be export processing zones, industrial parks, or even special economic zones. Each of them requires specific
Dr. Wickramanayake, you have 2 more
infrastructure,
minutes.
rules, and incentives. I have touched only on some aspects of the new law. There are other features that are equally important, which I urge you to take a look at when you have the time. The interlocking between the EEC, Zone Sri Lanka, and the Office of International Trade should have a remarkable impact on creating a more cohesive system of investment and trade. There are special provisions on granting incentives, making the process more targeted and transparent. The composition of the EC has been elevated to require more serious engagement from the public and private sector. There are provisions to make rulemaking more inclusive. More efficient dispute resolution systems have been included. I cannot hope to cover all of them during this short time. I want to leave you with one final thought. Any law, however good, will remain academic unless the stakeholders actively make it work. Provision has been made in this new law for private sector participation at every level. The board of the EC giving investors rights to participate in rulemaking and also to seek accountability. But effective application of regulation requires passion, vision, and engagement, particularly from the private sector and professionals like you and I. So unless we see this type of engagement, we will continue to drift and the status quo is going to remain. Thank you.
Thank you very much, Dr. Wickramanayake, for taking us through some salient features of the Economic Transformation Act number 45 of 2024. I'm sure there will be many questions. Now, I open now the session for questions from the audience. Now to start with, let me pose a question to Lihini on her topic. Now, the amendment that she was referring to, that is the basically chapter 32 of the Intellectual Property Act, especially with regard to the geographical protection indications. Now we find in the amendment that was introduced in the year 2018 as well as 2022, the lawmakers have used the words any interested party shall be entitled to prevent, and also with regard to the applications, it says any association of persons. So in that context, let me ask you, how do we identify who is the person who is entitled to apply for a geographical registration? Because there seems to be some ambiguity when it seems to be very broad and wide, but they use the word any person and also association of persons, which is not defined in the new law, in the amendments. Can you please answer that?
Yes. In fact, now we have to come out from the mentality of, trademarks. So geographical indications are, of course, collective rights. So there can be producer associations which apply for GI registrations in terms of the newly introduced Amendment Act. And at the same time, there can be governmental authorities which initiate this registration process. That is because we follow the Indian approach. In India, so to show that these governmental entities represent the interests of the GI producers, the registry requires an affidavit, because not all governmental entities can just go and apply for GI registration. So they have to show that they represent the interests of the GI producers. So in Sri Lanka also, so since we are following the Indian approach, producer associations as well as the governmental entities can apply for GI registration. But the issue is now Sri Lanka is very, we are trying to register these geographical indications in European Union also. No? So anyway, now we have already registered Ceylon cinnamon in EU. So if we are to apply EU registration, then the problem is they only accept producer associations. So therefore, in registering even Ceylon cinnamon in European Union, we had to establish a producer association. So ultimately, my opinion is that there has to be a producer association which apply for GI registration, then we can easily apply for EU registration as well. So the benefit of getting the registration in European Union is because EU is a model recognized by many countries in the world when it comes to geographical indications. So we can be benefited if we are registering our geographical indications in European Union. So my understanding and my opinion is that it has to be a producer association, although the governmental authorities recognized by the law can also apply for GI registration.
Thank you, Lihini. Why I asked you that question is now we have a culture in this country that people, especially in today's context, people register political parties. And close upon to an election, they are in the process of like merchandising or selling those political parties after obtaining registration. So because the Act uses the words any person or any person especially, I think it's very broad. So I think you made a clarification on that, that you have to have some interest in the geographical, in the process.
Yes, correct.
So that seems to be, I think, a satisfactory answer. Now, I also have a question for Harsha for your very insightful presentation. Now, Sri Lanka being ranked the 164th out of 190 countries in the world for the enforcement of contracts. What mode of law reforms could be implemented in the commercial law sector to expedite the wheels of justice, in your opinion?
Do you want me to do the presentation again?
No, just if you need a clarification on that. I mean, that's a very specific question.
Yeah, I think the point I was making is we need to separate the substance of the law from the enforcement side. So I think if you look at the substance of our laws, I think we are fairly okay because we look at the international standards and we try to sort of copy and paste that. That's what we tend to do. But when it comes to enforcement, I think there is a lot that needs to be done within the enforcement mechanisms to enhance its processes, to enhance its speed. And I think we also need, especially including us lawyers, a complete mindset change as to how we approach commercial disputes. I mean, stay orders are given at a drop of a hat. Stay orders can be obtained at a drop of a hat. I have also been guilty of that. But we tend to forget the underlying consequences. We completely forget the underlying business transaction when we have commercial disputes. So the substance of the law, I am not really having an issue with that. It's that interaction, that substance with the business community and the enforcement mechanism and sometimes the regulator. So we have not reached that consensus to the level that we need to take. So answering your question, how do you improve this? There is no one answer. You need to take a systemic answer. And that's why I cited that Indian example, where they did the business ranking as a project and then did so many different angles at the same time, concurrently. We started that. I think there's a committee that's going on enforcement of business enterprise. But again, the key stakeholders are not included. I mean, judiciary is on its own. Ministries are separating on their own. That locus of power is missing to bring in that overall reform. So as Arittha mentioned, that power that the presidency had is now not used. We don't have it anymore. And even when we had it, we didn't use it for these purposes.
Yeah, thank you, Harsha. Now, with regard to the Economic Transformation Act, Arittha's topic, I think I came prepared with some questions for you. I mean, with the Economic Transformation Act coming into force, the Board of Investment, Act number 4 of 1978 was repealed with immediate effect. Now, and 5 new entities were created and established: the Sri Lanka Economic Commission, Sri Lanka Investment Zones, Office for International Trade, National Productivity Commission, and the Sri Lanka Institute of Economics and International Trade. So while this restructuring of the BOI, potentially will that undermine the integrated support system that currently facilitates over 2,000 projects under the BOI which has been registered?
No, that's not correct, Kuvera, for the reason that the Act grandfathers what the BOI has done. So there is continuity, like every other law. There's continuity of what took place under the BOI. Those contracts will remain, the employees will remain, right? So it's just a structure that really changes. So this whole thing about the previous projects that were approved will suffer is a complete fallacy.
Thank you for that. And now, with the creation of these entities under the economic ETA, will that alone contribute to attract the FDIs, or in your opinion?
No, as I told you, bringing any law is useless unless you have proper people to run the institutions, right? one of the reasons that the BOI failed is perhaps not merely because of the law. It is because of the people who were appointed.
Correct.
You know, but it was a completely demoralized institution. As I said, it was overstaffed. People had no passion. Nobody knew where they were going. I'll give you a simple example. The chairman of the BOI was the chairman of the port city. Okay, they're two competing entities. But how do you expect an institution like the BOI to survive when across the road people are offering much better incentives? And they were the new darlings of the politicians. So you have to there comes a time when you got to replace an institution and recreate it. So that's why, you know, do you know who the members of the BOI are today? No, I don't know who they are. Harsha, do you know who they are? Mr. Davatawala, do you know who the members of the BOI are? Nobody gives
No
a
idea,
damn.
no idea.
Right, just no stature anymore. So that's why we created an institution with higher profile membership and the ability to bring in more private sector people into it. So hopefully they will drive it forward. But you need a complete reset, a complete set of thinking if you're going to make these institutions work. It's a different ball game.
Correct. Now, as Harsha also said, now has the ETA been able to sort of address this one-stop concept, shop concept? Has it been? Does it adequately deals with that?
So the ETA has given a lot of powers and a lot of direction to the Commission. Right? Their mandate has been defined. They have to formulate the policies, and that will be included in the National Policy of Economic Transformation. Right? So once that's done, that becomes a national vision. It must be followed, and you got to periodically review it and report on what's happening. That should keep people on their toes. Right? To that extent, it changes the whole set of thinking.
So in your opinion, it is adequately addressed to a certain point?
I think, take even things like zones, for instance. Now, there's a lot of resistance to zones being taken out of the BOI and letting private participation into it. You had to do it, right? Because the concept of zones has changed dramatically over the years, right? It's not that first generation zone that can survive. Take tech, for instance. There's a huge investment that's required to be able to set up those zones, right? And you've got to go overseas and market those zones, which we can't do. Then this new law also permits them to set up this new entity called Invest Sri Lanka, which will focus entirely on investment promotion. Now the BOI tried that. They bought some higher paid people into the BOI to do that, and they went on strike. So you can't work in the present system. You got to change it.
There are some questions from the audience. I think this is directed to Lihini. Are only tangible goods considered under geographical indicators? Can the skills be registered under the geographical indicators, especially the Kandyan dancing and Kapirinya singing, etc.?
No. So far, only goods can be registered as geographical indications, and even European Union or any other country has not taken any steps to register any like sort of Kandyan dances and those sort of things as geographical indications, although they can be limited to a particular geographical area. So only goods are registered as geographical indications.
Correct, because the definition also under the producer gives a certain
Yes.
the goods that
Yeah.
can be registered. Right, thank you. So then there's also, can the geographical indicators treated as goodwill? If so, can provisions applicable for goodwill apply on geographical indicators?
Can be treated as?
Can the geographical indicators treated as goodwill?
Okay. So goodwill in the sense like if a particular product has certain qualities, it can be reputation or characteristics as a result of a particular geographical area, still it can be registered as a geographical indication. So that is because of this TRIPS agreement, which now allows to register or recognize geographical indications solely because of the reputation as well. Earlier in France, there has to be some physical, I mean, it has to be, a product has to be linked with the physical environment. But now the situation has changed and the definition has been broadened. So therefore, even the products which have, have the reputation because of the geographical origin, still they can be recognized as geographical indications, and which is different from the French concept appellation of origin, which goes back to many centuries. So the situation has now changed. Yeah.
Then I think this question is directed to Harsha. Breach of administrative laws or exerting excessive administrative laws are common in Sri Lanka. What are your views to minimize the actions of ultra-vires?
I think there are too many lawyers in the audience. No, I think once again the context is we need to understand what's the role of a public official, what's the role of the government. You see, with due respect, I think there is also this, I would say, a misplaced understanding that private sector is also the answer to all our problems. It's not. I've seen some of the private sector guys who have been given authority operate in ways worse than a public official. I think what's important is to understand why you are given discretion and what's the purpose by which that discretion is exercised. So to that extent, actually, I would refer to the ETA, the Economic Transformation Act. At the very beginning, it has a section, it says, you must achieve these economic growth rates. You have to, sort of very broad outcomes are given in the act. I think probably one of the first acts that gave that, which is, I think, to some extent, from an economic point of view, it's measurable in terms of digits and numbers. So that way, you can interpret that this law is attempting to focus everybody towards a very clearly defined goal. So that kind of lack of vision, leadership, policy, that is where the public officials are have become a law unto themselves. Even if you look at policies in Sri Lanka, policy implementation is a big issue. Forget legal implementation, policy implementation. So we might even have a cabinet appointed, approved policy. Then we have the 9 provinces which have their own policies with regard to the subjects in the provincial council list. So this dissonance in policy is also creating problems for decision makers. So I think answering your question, I wouldn't sort of limit it to ultra-vires in a legal sense, but I would say it's that inability to understand your role within a policy as set, which hopefully should have a long-term implementation life cycle, maybe 5 years at least. So within that 5 years, everybody falls in line and they should be able to justify their decisions in conformity with that policy. And that kind of links to the accountability, not only in terms of bribery and corruption, but accountability to policy implementation. You promise that you will get this result on the ground. Now justify your decision or your action in terms of that. That is missing. I mean, if you look at the Economic Crisis Act judgment given by the Supreme Court, everybody who was found fault with that are still operating in decision-making roles.
Thank you. Any questions from the audience? Maybe final question to you, Arittha. I think we have enacted the Public Debt Management Act, number 33 of 2024, and the Public Financial Management Act, number 44 of 24, and the ETA. Now, do you think, keeping in line with the theme of this conference, are we on the right path or on the right track towards Sri Lanka's sustained economic growth? Yeah, I mean, if you can give a very brief answer with the time constraints.
Look, in my opinion, the foundation has been set, right? And it has been set in the most pragmatic way possible. Whether the law will get it done or not, it's not really a question of law. It is a question of people, right? We have a lot of people complaining all over today. But how many of us actually engage in this? How many of us are willing to serve, right? Our country has a people problem. No, we like to sit back and whine all the time. In fact, yesterday I sent an email to somebody, we are all on the keyboards complaining. We go to cocktail parties and we whine. How many of us have actually spent time serving, engaging, making constructive, giving constructive criticism? So unless we do that, right, this thing is not going to work. It will be another piece of paper. So it's the people who will be there who will make a change. You take all our regulatory bodies, you look at the performance, ultimately it's accountability. The people, they make the change. Harsha, what do you say?
Yeah, and the other thing is also, I think these are institutions. I mean, they're good on paper, as Arittha mentioned. But if you look at the policy debate now, run up to an election, I was actually hoping to see policy debates on these issues. No. A lot of the people who are talking about it have no idea, including the professionals, have no idea what they're talking about. So if you are seriously a policy observer, and you're waiting for the people who are going to be leaders to see their perspective on the policies that you can make an investment decision today, that's not coming.
Kuvera, you can lead a horse to water, but you can't make it drink. Correct. So the water has been prepared. It's up to the horse to go and drink it.
Correct.
If the horse doesn't do it, too bad.
Point is that the IMF, the catalytic impact of the IMF. I mean, I know we have our mixed views about the IMF, but recently I saw the president had invited the two presidential candidates to have a live discussion on the IMF, with the IMF. Now, I don't know whether it's a political gimmick or not, but at least that is where we have got a catalytic intervention coming from an external funder, and the other multilateral funders are following the trend. The World Bank and the ADB are set by the IMF, because they all take a sort of this thing. Then you're asking with the people who are aspiring leader or to the positional leadership, have that conversation and let us know how they feel about these things. If it's not good, tell it now. So the investors, the professionals, the citizens, we can make their decisions accordingly, even to migrate.
Thank you very much. I think time is up for us. Let me thank Lihini, Ms. Lihini de Silva, for that very insightful on geographical registrations in terms of the IP Act, and Harsha for that very thought-provoking, Harsha and both Arittha, and Arittha for taking us through the ETA, and also for the valuable contribution that you made with regard to the questions that arose on your presentations. And let me also thank the organizers, the OPA, for giving us this opportunity on behalf of all the speakers and for myself. And I wish all the very best to the OPA in their future endeavors, and hopefully what has been discussed here today, I'm sure will be formulated and presented to the stakeholders for their consideration at some future date. Thank you very much. And
thank you very much. We'd now like to present tokens of appreciation to our speakers on stage. I'd like to invite Mr. Tissera de Silva, General Secretary of the OPA, also Mr. Sarath Gamage, President OPA, Mr. Sujiva Lal Dahanayaka, President-elect OPA, also Chairman of the Conference Committee, to join us up on stage now. We would like to invite Mrs. Ruchira, who is our immediate past president, to join us up. And we will now be presenting the tokens of appreciation. Let's get started with the chairman of this session on law reforms and enhancing regulatory frameworks. The chairman for this session has been Mr. Kuvera de Zoysa, President's Counsel. We'd like to appreciate your time and expertise with us, sir. We have a token of appreciation coming your way. Let's put our hands together for our session chair, ladies and gentlemen, Mr. Kuvera de Zoysa, President's Counsel. Up next, we'd like to appreciate Ms. Lihini de Silva. Ms. Lihini de Silva is Head of the Department of Public Law, Faculty of Law, General Sir John Kotalavala Defence University. We thank Ms. Lihini de Silva for her presence here on our panel. Let's put our hands together for our speaker, ladies and gentlemen. Up next, we would like to appreciate the presence of Mr. Harsha Fernando, President's Counsel. We have a token of appreciation coming your way on behalf of the OPA. Let's put our hands together for Mr. Harsha Fernando, President's Counsel. And we have one more panelist that we would like to appreciate. We have Dr. Arittha Wickramanayake. So we'd like to invite you. Let's put our hands together as we appreciate Dr. Arittha Wickramanayake. And with that, ladies and gentlemen, we wrap up this session. Let's put our hands together for all of our speakers on stage yet again. Thank you for your time, presence, and your expertise. We invite you now to please take your seats in the audience.